Please subscribe, like and share this content. It means a lot to us. Thank you in advance.
Cornell Law School.
U.C.C. Article 9. Secured Transactions.
Part 6. Default. Subpart 1. Default and Enforcement of Security Interest. Paragraph 9609. Secured parties' right to take possession after default. A. Possession. Rendering equipment unusable. Disposition on debtor's premises. After default, a secured party 1. May take possession of the collateral, and 2. Without removal, may render equipment unusable and dispose of collateral on a debtor's premises under Section 9610. B. Judicial and non-judicial process. A secured party may proceed under subsection A. 1. Pursuant to judicial process, or 2. Without judicial process, if it proceeds without breach of the peace. C. Assembly of collateral. If so agreed, and in any event after default, a secured party may require the debtor to assemble the collateral and make it available to the secured party at a place to be designated by the secured party which is reasonably convenient to both parties. Paragraph 9610. Disposition of collateral after default. A. Disposition after default. After default, a secured party may sell, lease, license, or otherwise dispose of any or all of the collateral in its present condition or following any commercially reasonable preparation or processing. B. Commercially reasonable disposition. Every aspect of a disposition of collateral, including the method, manner, time, place, and other terms, must be commercially reasonable. If commercially reasonable, a secured party may dispose of collateral by public or private proceedings, by one or more contracts, as a unit or in parcels, and at any time and place and on any terms. C. Purchase by secured party. A secured party may purchase collateral 1. At a public disposition, or 2. At a private disposition only if the collateral is of a kind that is customarily sold on a recognized market or the subject of widely distributed standard price quotations. D. Warranties on disposition. A contract for sale, lease, license, or other disposition includes the warranties relating to title, possession, quiet enjoyment, and the like which by operation of law accompany a voluntary disposition of property of the kind subject to the contract. E. Disclaimer of warranties. A secured party may disclaim or modify warranties under subsection D. 1. In a manner that would be effective to disclaim or modify the warranties in a voluntary disposition of property of the kind subject to the contract of disposition, or 2. By communicating to the purchaser a record evidencing the contract for disposition and including an express disclaimer or modification of the warranties. F. Record sufficient to disclaim warranties. A record is sufficient to disclaim warranties under subsection E if it indicates there is no warranty relating to title, possession, quiet enjoyment, or the like in this disposition or uses words of similar import. Paragraph 9611. Notifications before disposition of collateral. A. Notifications date. In this section, notifications date means the earlier of the date on which 1. A secured party sends to the debtor and any secondary obliger an authenticated notification of disposition, or 2. The debtor and any secondary obliger waive the right to notification. B. Notification of disposition required. Except as otherwise provided in subsection D, a secured party that disposes of collateral under Section 9610 shall send to the persons specified in subsection C a reasonable authenticated notification of disposition. C. Persons to be notified. To comply with subsection B, the secured party shall send an authenticated notification of disposition to 1. The debtor, 2. Any secondary obliger, and 3. If the collateral is other than consumer goods, A. Any other person from which the secured party has received, before the notification date, an authenticated notification of a claim of an interest in the collateral. B. Any other secured party or lien holder that, 10 days before the notification date, held a security interest in or other lien on the collateral perfected by the filing of a financing statement that I. Identified the collateral, 2. Was indexed under the debtor's name as of that date, and 3. Was filed in the office in which to file a financing statement against the debtor covering the collateral as of that date, and C. Any other secured party that, 10 days before the notification date, held a security interest in the collateral perfected by compliance with a statute, regulation, or treaty described in Section 9(311)(a). D. Subsection B. Inapplicable. Perishable collateral. Recognized market. Subsection B does not apply if the collateral is perishable or threatens to decline speedily in value or is of a type customarily sold on a recognized market. E. Compliance with subsection C(3)(b). A secured party complies with the requirement for notification prescribed by subsection C(3)(b) if 1. Not later than 20 days or earlier than 30 days before the notification date, the secured party requests, in a commercially reasonable manner, information concerning financing statements indexed under the debtor's name in the office indicated in subsection C(3)(b), and 2. Before the notification date, the secured party A. Did not receive a response to the request for information, or B. Received a response to the request for information and sent an authenticated notification of disposition to each secured party or other lien holder named in that response whose financing statement covered the collateral. Paragraph 9612. Timeliness of notification before disposition of collateral. A. Reasonable time is question of fact. Except as otherwise provided in subsection B, whether a notification is sent within a reasonable time is a question of fact. B. 10-day period sufficient in non-consumer transaction. In a transaction other than a consumer transaction, a notification of disposition sent after default in 10 days or more before the earliest time of disposition set forth in the notification is sent within a reasonable time before the disposition. Paragraph 9613. Contents and form of notification before disposition of collateral, general. Except in a consumer goods transaction, the following rules apply. 1. The contents of a notification of disposition are sufficient if the notification A. Describes the debtor and the secured party. B. Describes the collateral that is the subject of the intended disposition. C. States the method of intended disposition. D. States that the debtor is entitled to an accounting of the unpaid indebtedness and states the charge, if any, for an accounting, and E. States the time and place of a public disposition or the time after which any other disposition is to be made. 2. Whether the contents of a notification that lacks any of the information specified in paragraph 1 are nevertheless sufficient is a question of fact. 3. The contents of a notification providing substantially the information specified in paragraph 1 are sufficient, even if the notification includes A. Information not specified by that paragraph, or B. Minor errors that are not seriously misleading. 4. A particular phrasing of the notification is not required. 5. The following form of notification in the form appearing in Section 9614(3), when completed, each provides sufficient information. Notification of disposition of collateral. 2. Name of debtor, obliger, or other person to which the notification is sent. From, name, address, and telephone number of secured party. Name of debtor, S. Include only if debtor, S. are not an addressee. For a public disposition, we will sell, or lease or license, as applicable. B. Describe collateral, to the highest qualified bidder in public as follows. Day and date, time, place. For a private disposition, we will sell, or lease or license, as applicable. B. Describe collateral, privately sometime after, day and date. You are entitled to an accounting of the unpaid indebtedness secured by the property that we intend to sell, or lease or license, as applicable, for a charge of $. You may request an accounting by calling us at telephone number. End of form. Paragraph 9614. Contents and form of notification before disposition of collateral, consumer goods transaction. In a consumer goods transaction, the following rules apply. 1. A notification of disposition must provide the following information. A. The information specified in Section 9613(1). B. A description of any liability for a deficiency of the person to which the notification is sent. C. A telephone number from which the amount that must be paid to the secured party to redeem the collateral under Section 9623 is available, and D. A telephone number or mailing address from which additional information concerning the disposition and the obligation secured is available. 2. A particular phrasing of the notification is not required. 3. The following form of notification, when completed, provides sufficient information. Name and address of secured party. Date, Notice of our plan to sell property. Name and address of any obliger who is also a debtor. Subject, identification of transaction. We have your described collateral, because you broke promises in our agreement. For a public disposition, we will sell described collateral at public sale. A sale could include a lease or license. The sale will be held as follows. Date. Place. You may attend the sale and bring bidders if you want. For a private disposition, we will sell described collateral at private sale sometime after date. A sale could include a lease or license. The money that we get from the sale, after paying in our costs, will reduce the amount you owe. If we get less money than you owe, you will or will not, as applicable, still owe us the difference. If we get more money than you owe, you will get the extra money, unless we must pay it to someone else. You can get the property back at any time before we sell it by paying us the full amount you owe, not just the past due payments, including our expenses. To learn the exact amount you must pay, call us at telephone number. If you want us to explain to you in writing how we have figured the amount that you owe us, you may call us at telephone number or write us at secured party's address and request a written explanation. We will charge you $1 for the explanation if we send you another written explanation of the amount you owe us within the last 6 months. If you need more information about the sale, call us at telephone number or write us at secured party's address. We are sending this notice to the following other people who have an interest in described collateral or who owe money under your agreement. Names of all other debtors and obligers, if any. End of form. 4. A notification in the form of paragraph 3 is sufficient, even if additional information appears at the end of the form. 5. A notification in the form of paragraph 3 is sufficient, even if it includes errors and information not required by paragraph 1, unless the error is misleading with respect to rights arising under this article. 6. If a notification under this section is not in the form of paragraph 3, law other than this article determines the effect of including information not required by paragraph 1. Paragraph 9615. Application of proceeds of disposition. Liability for deficiency and right to surplus. A. Application of proceeds. A secured party shall apply or pay over for application the cash proceeds of disposition under section 9610 in the following order to 1. The reasonable expenses of retaking, holding, preparing for disposition, processing, and disposing, and, to the extent provided for by agreement and not prohibited by law, reasonable attorney's fees and legal expenses incurred by the secured party. 2. The satisfaction of obligations secured by the security interest or agricultural lien under which the disposition is made. 3. The satisfaction of obligations secured by any subordinate security interest in or other subordinate lien on the collateral if a. The secured party receives from the holder of the subordinate security interest or other lien an authenticated demand for proceeds before distribution of the proceeds is completed, and b. In a case in which a consignor has an interest in the collateral, the subordinate security interest or other lien is senior to the interest of the consignor, and 4. A secured party that is a consignor of the collateral if the secured party receives from the consignor an authenticated demand for proceeds before distribution of the proceeds is completed. B. Proof of subordinate interest. If requested by a secured party, a holder of a subordinate security interest or other lien shall furnish reasonable proof of the interest or lien within a reasonable time. Unless the holder does so, the secured party need not comply with the holder's demand under subsection A3. C. Application of non-cash proceeds. A secured party need not apply or pay over for application non-cash proceeds of disposition under section 9610 unless a failure to do so would be commercially unreasonable. A secured party that applies or pays over for application non-cash proceeds shall do so in a commercially reasonable manner. D. Surplus or deficiency if obligation secured. If the security interest under which a disposition is made secures payment or performance of an obligation, after making the payments and applications required by subsection A and permitted by subsection C. 1. Unless subsection A4 requires the secured party to apply or pay over cash proceeds to a consignor, the secured party shall account to and pay a debtor for any surplus, and 2. The obliger is liable for any deficiency. E. No surplus or deficiency in sales of certain rights to payment. If the underlying transaction is a sale of accounts, chattel paper, payment intangibles, or promissory notes, 1. The debtor is not entitled to any surplus, and 2. The obliger is not liable for any deficiency. F. Calculation of surplus or deficiency and disposition to person related to secured party. The surplus or deficiency following a disposition is calculated based on the amount of proceeds that would have been realized in a disposition complying with this part to a transferee other than the secured party, a person related to the secured party, or a secondary obliger if 1. The transferee in the disposition is the secured party, a person related to the secured party, or a secondary obliger, and 2. The amount of proceeds of the disposition is significantly below the range of proceeds that a complying disposition to a person other than the secured party, a person related to the secured party, or a secondary obliger would have brought. G. Cash proceeds received by junior secured party. A secured party that receives cash proceeds of a disposition in good faith and without knowledge that the receipt violates the rights of the holder of a security interest or other lien that is not subordinate to the security interest or agricultural lien under which the disposition is made. 1. Takes the cash proceeds free of the security interest or other lien. 2. Is not obligated to apply the proceeds of the disposition to the satisfaction of obligations secured by the security interest or other lien, and 3. Is not obligated to account to or pay the holder of the security interest or other lien for any surplus. Paragraph 9/616. Explanation of calculation of surplus or deficiency. A. Definitions. In this section, 1. Explanation means a writing that A. States the amount of the surplus or deficiency. B. Provides an explanation in accordance with subsection C of how the secured party calculated the surplus or deficiency. C. States, if applicable, that future debits, credits, charges, including additional credit service charges or interest, rebates, and expenses may affect the amount of the surplus or deficiency, and D. Provides a telephone number or mailing address from which additional information concerning the transaction is available. 2. Request means a record. A. Authenticated by a debtor or consumer obliger. B. Requesting that the recipient provide an explanation, and C. Sent after disposition of the collateral under Section 9/610. B. Explanation of calculation. In a consumer goods transaction in which the debtor is entitled to a surplus or a consumer obliger is liable for a deficiency under Section 9/615, the secured parties shall 1. Send an explanation to the debtor or consumer obliger, as applicable, after the disposition and A. Before or when the secured party accounts to the debtor and pays any surplus or first makes written demand on the consumer obliger after the disposition for payment of the deficiency, and B. Within 14 days after receipt of a request, or 2. In the case of a consumer obliger who is liable for a deficiency, within 14 days after receipt of a request, send to the consumer obliger a record waiving the secured party's right to a deficiency. C. Required information. To comply with subsection A(1)(b), a writing must provide the following information in the following order. 1. The aggregate amount of obligations secured by the security interest under which the disposition was made, and, if the amount reflects a rebate of unearned interest or credit service charge, an indication of that fact, calculated as of a specified date. A. If the secured party takes or receives possession of the collateral after default, not more than 35 days before the secured party takes or receives possession, or B. If the secured party takes or receives possession of the collateral before default or does not take possession of the collateral, not more than 35 days before the disposition. 2. The amount of proceeds of the disposition. 3. The aggregate amount of the obligations after deducting the amount of proceeds. 4. The amount, in the aggregate or by type, and types of expenses, including expenses of retaking, holding, preparing for disposition, processing, and disposing of the collateral, and attorney's fees secured by the collateral which are known to the secured party and relate to the current disposition. 5. The amount, in the aggregate or by type, and types of credits, including rebates of interest or credit service charges, to which the obliger is known to be entitled and which are not reflected in the amount in paragraph 1, and 6. The amount of the surplus or deficiency. D. Substantial compliance. A particular phrasing of the explanation is not required. An explanation complying substantially with the requirements of subsection A is sufficient, even if it includes minor errors that are not seriously misleading. E. Charges for responses. A debtor or consumer obliger is entitled without charge to one response to a request under this section during any 6-month period in which the secured party did not send to the debtor or consumer obliger an explanation pursuant to subsection B1. The secured party may require payment of a charge not exceeding $25 for each additional response.